I've been ordered removed. Can I still stay in the country despite my removal order? We're going to talk about those ways where a non-citizen can still stay in the country despite the removal order. Okay. Number one, appeals. So basically, once the immigration judge has ordered an individual removed, well, that person really has to appeal, right? You have to file your appeal with the Board of Immigration Appeals to stay the removal order. It simply means that while the Board of Immigration Appeals is deciding on your case, you can still stay in the country. And let's say they decide on your case, it doesn't work out, still the same decision, they maintain the decision of the immigration judge. What are you going to do? You can get the federal court to review the decision of the Board of Immigration Appeals. Meanwhile, you can still stay in the country while the matter is being decided. Well, you have to file that appeal within 30 days of the decision, unless you meet some type of exception. Maybe you were ordered removed in absentia and you have good cause, stuff like that. But the general rule is that you have to file the appeal within 30 days, okay, of the immigration judge decision. That's one way, appeals, and follow through on all levels, right? So number two is that once you did that and it didn't work out, what can you do? You can try two things, right? You can first try to stay removal by filing a not cancellation of removal, but application for stay of removal. You file it directly with ICE. That's one way. If they might agree, you never know, you have to try. Or you can, go with deferred action, still try to ask for ICE to give you some type of status in terms of, by agreement based on humanitarian reasons or based on medical reasons. It happens a lot. They give people deferred actions. It's just discretionary, but case-by-case basis, it's something to try once you've tried to appeal and you did not succeed, right? That was number two. Number three, motions to reopen, okay? You can file a motion to reopen within 90 days. That's the deadline. That's the general rule, but there are a few exceptions where you can file it even outside of the deadlines if you meet those type of exceptions. I'm not going to focus on that, but I'm just talking about in general, you can file a motion to reopen your case. And what are you going to do when you file a motion to reopen your case? You have to combine it or separately motion to reopen, then motion to stay removal. So meaning what? Meaning that once they're trying to reopen your case, they can stay that removal order. Basically, can stay in the country until they decide on the fate of your motion to reopen. Okay, and if there is some type of an emergency, let's say the person has been detained by ICE, you can try to make it as an emergency by filing an emergency motion to stay with the Board of Immigration Appeals, depending where the case was last heard, right? So those are some ways. I'm not saying those are the only ways, but those are some ways where you can stay in the country while your case, despite the order of removal, and while your case is pending on appeal, or the motion to reopen is pending with BIA or immigration court, depending on where you were last heard. Okay. I'm not doing any live sessions until next year because we're trying to see, when Donald Trump get back to power, he's going to sign some executive orders. So we want to wait until he starts signing those executive orders so we can come back and try to discuss those. And, that's when we'll resume with our live sessions on YouTube and Instagram. Follow me for more. Until next time, bye-bye.